handle for each of directors to get. So it adopts both what I call an objective and a subjective test. A subjective test meaning that we first look at the relevant skills and knowledge of the particular director, experience, skills, knowledge, education, etc. Objective in the sense that we judge that behaviors and activities of that director in relation to a reasonable businessman occupying that position. In other words, what a reasonable businessman or reasonable director in that role would have done or should have done. Now, what we're going to look at this week is we'll revisit that rule, the rule relating to directors' duty of care, and then we'll also look at the other law relating to directors' duties. So, for example, what if you are a director and you learn of a business opportunity while you are negotiating on behalf of the company? And while doing that, you realize there was a business opportunity, and as a result, you grab that business opportunity instead of negotiating with or on behalf of the company. And the next question is, would you be held liable? Or, what if you're a director of a company, and you and your wife had another business outside, and then you decide that you and your wife's business would provide a particular service or sell a particular asset to a company. Now, would that director be held liable, or should that director be held liable? And these are some of the things that we'll look at today in detail. Okay, so we'll first revisit the law on duty of care, and we'll compare the traditional common law concept and the more modern common law position. And then we'll also look at the rules on the Companies Ordinance, which is section 465 of Companies Ordinance in Hong Kong. And then we'll also look at the conflict of interest and no secret profit rules later on. Now, the duty of a director, the duty of a director to exercise what we call reasonable care, skill, and diligence was originally developed under the common law in the late 19th century and early 20th century. Now, what statutes have done in the UK, for example, they have introduced now section 174 of the Companies Act 2006, which we'll look at later, is equivalent here in Hong Kong to section 465 of the Companies Ordinance. Now, in the past, what I said last week was, in the past, in other words, when the rule was first developed, in the latter part of 19th century and early 20th century, was that the rule governing directors' duty took a very lax approach in determining directors' liability. Now, in other words, what that meant was, the court generally adopted a subjective test, a subjective test in determining the liability of a director. In other words, it looked at the relevance, mainly focused on the relevant skills, knowledge, education level, experience of that particular director. Now, the reason for that was, the early 20th century view was that directors, they are just businessmen. Okay? They are just businessmen. In other words, if they are businessmen, when they run the business, they are supposed to take risks. And if the business fails, it is not for the court to determine whether or not the directors should or should not be liable. Now, but as we'll look at later, the more modern approach is that more is expected of a director. And if directors lack the necessary knowledge, then they should themselves go and update on their skills. So in other words, the more modern view is, to put it simply, right, directors, okay, ought to be more professional if they occupy the position of a director. Now, the traditional common law concept was first developed in a case called the City Equitable. Now, what happened in this case was the company lost £1.2 million in failure of investment and also large-scale fraud activities committed by the company's chairman. Right, so remember, right, this was 1920s, okay? So £1.2 million was a lot of money back then. So what happened was, after the company went into liquidation, the liquidator then took legal actions against the other directors for negligence. Now, what the Court of Appeal held in this case was, on the facts, the directors were all honest, and as a result of that, they were exonerated by provisions in the company's articles. So in other words, they were not liable. And what the court did in this case was they stipulated that a more subjective standard of competence should apply. Okay? A more subjective standard of competence should apply to directors. Now, what the court even said was, right, a director is not even bound to give continuous attention of the company's affairs. So in other words, if you were appointed as director, right, the fact that you didn't attend any board meetings, that didn't matter. However, what Justice Romer did in that case was, he also mentioned that an objective standard can sometimes apply in determining the liability of a director. Okay? An objective standard can sometimes apply, right? The quote was, right, to be measured by the care an ordinary man might be expected to take in the circumstances on his own behalf. And this was later taken up here in Hong Kong by Justice Rogers VP in our Hong Kong case called Liu Wei Lin versus Bowman Construction Company. Now, the more modern approach in determining director's liability really started to develop in the late 80s and early 1990s. Now, this was first illustrated in a case called Daniels versus Anderson, which was an Australian case, delivered by the Supreme Court of New South Wales. Now, what happened in this case was, there was a company called AWA, and one of AWA's major activities was the importing and exporting of electronic products. Now, as the facts turn out, the company imported large quantities of electronic components from Japan. And to hedge against this, the company acquired a lot of foreign currency contracts. Okay, so to hedge against foreign currency fluctuations, they acquire a lot of foreign currency contracts. Now, in December 1985, someone called Mr. Cole was appointed as the foreign exchange manager of AWA. Now, at first, he appeared very successful and seemed to have been making huge profits on foreign exchange dealings. Now, to cut a long story short, what happened was, by about July 1987, it was revealed that AWA had actually lost almost 50 million Australian dollar from foreign exchange operations because of the misdeed committed by Mr. Cobb. So basically, they appointed this person who claims to be a foreign exchange expert to deal with its foreign currency contracts. Seemed very successful at first, but eventually lost 50 million Australian dollars for the company. So the issue before the court was, were the other directors of AWA responsible for the company's loss? Now, what a Court of Appeal in New South Wales held was, right? Quote, it's now more than 70 years since the decision in City Equitable. Okay, the court first said, right? It's now 70 years since the English court decision in City Equitable. And the Court of Appeal held that the standard and care and skill expected of directors should now be objective and higher. Okay? The standard of duty of care of directors, 70 years after City Equitable, right? Because as our society has now improved, right? Standard ought to improve as well. Expectation from director should be upgraded as well. Now, what the court also said here was, right, special qualifications of the director will be relevant in determining the scope of his or her duty of care. Special qualifications of a particular director will be relevant in determining the scope of his or her duty of care. Now, what happened in this case was the directors in question here, they were all experienced businessmen who had served or were serving on the boards of a lot of prominent and successful companies. So basically what the court is saying, right, given that you're such an experienced businessman and have been directors of so many companies, right, more is expected of you. So that's what we mean by both an subjective and objective test, okay? So we first look at the relevant skills, knowledge, experience, education level, etc., of a director. The more professional or more experienced he or she is, the more is expected of him or her. And taking into account of his subjective skills, we then look at the objective level of the test. What would a reasonable director occupying that position at the relevant time would have done or should have done? Now remember, right, the court, in determining the director's liability, okay, they are not looking at the merits of the decision. Now, because some business decision may increase profitability, some business decision can go wrong and cause severe loss to the company. So the court is actually not looking at the merits of the decision. What the court is really looking at is the procedural matter. In other words, did the director, or has the relevant director, done its homework properly before coming to that decision? So for example, right, what factors did they take into account? Did they conduct the necessary research or analysis before coming to that decision? Did they seek professional advice? Now what happened in this case was, right, in Daniel versus Anderson, was they delegated that duty, foreign exchange dealing, to someone that they thought was a foreign exchange expert. Now, of course, in a business, okay, it is of course possible and lawful for a director to delegate his or her duty to someone that they think have the professional skills and knowledge. That's absolutely fine. Now, but what courts have said was, despite the fact that you have delegated your duty to someone else, you should still remain in arm's-length supervision of that person. So it doesn't mean that the fact that you have delegated your duty, you are all of a sudden exonerated from all liability. So for example, even if you have delegated the duty to someone, right, you should constantly review what that person is doing. For example, right, have a regular meeting with that person, ask professional questions, and also make sure when you delegate your duty, you delegate that duty to the right person. Okay? So, for example, right, if you let's in this case, right, if it is about foreign exchange, okay, you better make sure that you delegate your duty to someone who knows about foreign exchange. Now, a similar case also occurred in the UK, which was called Re Dejean of London Limited. Now, what happened in this case was, Mr. Dejean held 99% shares of the company, and the remaining 1% was held by his wife. Now, what happened was, without properly reading a document, Mr. Dejean signed a change to an insurance policy, which was erroneously filled out by his insurance broker. So there was an insurance document, and he signed it without reading it. Now, what was relevant in this case was, he did not read it before he signed, and it contained a mistake, which was that the answer no was given to the question of whether in the past he had been director of any company which went into liquidation. So there was a question on the document, right, which asked him, were you ever a director of a company that went into liquidation? And he said no. Because as the facts turn out, he was once a director of a company that went into liquidation. Now, as a result of what happened, right, a fire broke out in the company's premise. And when the insurance company realized that mistake, they refused to pay up. And this caused a loss to the company of almost £180,000. Now, by the time Mr. Dejean realized the mistake on form, the company had already gone into insolvent liquidation. And when the liquidator discovered this, they sued Mr. Dejean to recoup the lost funds on behalf of the company's creditors. So basically, the liquidator tried to hold Mr. Dejean liable for the negligence and mistake. Now, the relevant provision here was Section 214 of the Insolvency Act 1986 in the UK. It says, right, Section 214, subsection 1, subject to subsection 3 below, if in the course of the winding of a company, if it appears that subsection 2 of this section applies in relation to a person who is or has been a director of a company, the court, on the application of the liquidator, may declare that the person is to be liable to make such contribution to the company's assets as the court thinks proper. So in other words, if in the course of winding up a company, If the court decides that someone ought to be held personally liable for the loss or liability suffered by a company, the court can do so. Providing that person at the time was a director or officer of the company. Now, the important provision here, right, is subsection 4, right? For the purpose of subsection 2 and 3, the facts which a director of a company ought to know or ascertain the conclusion which he ought to reach and the step which he ought to take are those which will be known or ascertained, taken by a reasonable, diligent person having both A, the general knowledge, skill, and experience of that person, general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same function, and B, the general knowledge, skill, and experience that the director has. So basically what the court is saying is, right, in determining whether or not the director is or is not liable in such a case, we adopt both an objective and a subjective test. Now, what Lord Justice Hoffman in this case said was, right, failing to even read the form properly was by itself negligent. Okay? Failing to read the form and the document properly was in itself a negligent behavior. And based on the fact, right, the court held what? The court held that the director was therefore liable for the loss incurred by the company. Now, here in Hong Kong, we have a similar statutory provision, which is Section 465 of Companies Ordinance, which is worded almost exactly the same as Section 174 of the UK Companies Act 2006. Okay, it says, well, a director of a company must exercise reasonable care, skill, and diligence. Reasonable care and skill and diligence means the care and diligence that would be exercised by a reasonable, diligent person with A, the general knowledge, skill, and experience that would be reasonably expected of the person, and B, the general knowledge, skills, and experience that the director has. So basically it's worded exactly the same, okay, as the UK provision. So if we first look at the level of knowledge and skill, experience that director has. So for example, right, if you're a lawyer, accountant, a financial expert, okay, more is expected of you if you occupy the position of a director. But even though if you do not have those skills or knowledge, okay, even if you do not have those skills and knowledge, you would still be judged by the objective standard. What would a reasonable director occupying that position would have done or ought to have done in such a situation? In other words, what it means is, if you are a director and if you do not have the necessary skills or knowledge, the law now expects you to update on your skills and knowledge. Or to put it simply, right, Re City Equitable, okay, Re City Equitable is now no longer good law, okay? Re City Equitable is now no longer good law. So what is the relationship, right? What is the relationship between the objective test and subjective test under section 174 or under section 465? Now, it was held in the case of Brunda versus Motornet Service Limited, the UK case. Now, what the court said was, on prima facie, the objective standard will always apply. However, the subjective standard will displace the objective standard if the particular director under consideration has greater knowledge, skill, and experience than may reasonably be expected of it. In other words, if the more qualified you are as a director, the more would be expected of you. So how do you think directors nowadays try to reduce the possibility of liability? Now, when Section 174 was first introduced in the UK and when Section 465 was first introduced in Hong Kong, okay, the fear was that it would discourage people from being directors. The fact that you increase the level of standard, individuals would be discouraged from being directors. Now, the way to get around this is what a lot of companies nowadays do, right? For directors, they have what we call insurance liability. Liability insurance for directors. So in other words, a lot of companies nowadays would acquire a liability insurance for its directors when they are appointed as directors. But just make sure that, right, if ever, right, you're appointed as director of a company, regardless of whether you're an independent non-executive director or an executive director, you are judged by the same standard and same skills level. Now, in the past, okay, the argument was if you are an independent non-executive director, less is expected of you because of the fact that you are part-time. Now, but the court in the UK and Australia have said, right, that is no longer the case, okay? Independent non-executive director and full-time executive director judged by the same standard and same expectation. So the advice is, right, if you ever act as a director, independent or non-independent, or full-time director, make sure you update your skills and knowledge of the business and the company. And more importantly, make sure you attend regular board meetings. Of course, if you're a director of a publicly listed company, then more is expected of you. Now, this was illustrated in a case called Goldribbon versus Shears, which was an Australian case, a Queensland court case. Now, what I read in this case was the only person in the board who has considerable lending experience was someone called Mr. Dunn. He was a non-executive director. Now, the company was in the business of lending money, okay, providing credit facilities. And for some reason, the only person in the board who had considerable lending experience was actually a non-executive director, called Mr. Dunn. Now, to cut a long story short, what happened was the loan of the money that the company advanced to its businesses in the end defaulted, and the company made a severe loss. And the question before the court was the director liable? Now, what's interesting in this case is, right, as I said, right, the only person who knew about lending business here was actually a non-executive director. So the issue before the court was, should we judge the behavior or standard of a non-executive director the same as the executive director? Now, what the Queensland court in this case held was, right, time has changed, okay? Time has changed. What that meant was, right, non-executive director and executive director ought to be judged by the same standard and same expectation. Now, another issue that the court answers is, what about delegation of duties? The fact that the other directors have delegated this duty to Mr. Dunn. Should they be held liable as well? Now, what the court said was, right, yes, as a director, if you do not have the professional skills and knowledge, then it is, of course, reasonable for you to delegate that duty to someone who you think has the skills and knowledge. However, in delegating that duty, the director still remains in arm's-length supervision of the delegatee. So in other words, you do not exonerate your liability simply by delegating your duty to someone else. Now, so the issue before the court was, why was Mr. Dunn held liable for breach of his duty under Section 180? Section 180, just for your knowledge, is worded similarly to Section 465 here in the Companies Ordinance, or Section 174 in the UK Companies Act. Now, the reason why he was held liable was he failed to ensure that the lending scheme was set up in compliance with accepting lending practice. One. Secondly, he failed to ensure that the scheme was administered by a competent person. So as I mentioned earlier, right, if you want to delegate your duty to someone, make sure that person you delegate to is someone who has the necessary skills and knowledge. Number three, in setting up and implementing the scheme, he failed to ensure that the terms and conditions of the loans and the administrative procedures were such as to minimize the risk of default by the borrowers. So in other words, he did not set the proper rules for returning the money. And most important of last but not least, right? The standard of care was fixed for him in light of his lending experience and expertise. So that's something I mentioned earlier, right? If by the objective standard, if by the subjective standard, if that person has the necessary skills and knowledge, the reasonable care expected of him can only rise, but not fall. Okay, so in other words, the more experienced you are, or the more professional you are, more is expected of you. So the fact that he was a non-executive director, according to the court, right, it was irrelevant. Because executive director, non-executive director, or independent non-executive director, according to the court, judged by the same standard. Now, but as the Queensland court held, right, based on the facts, despite the fact that he was liable, based on the fact, okay, the breach of duty committed by Mr. Dunn did not actually cause the loss suffered by the company. Now, because evidence show that the company would have approved the VAT loan, even if Mr. Dunn had supervised the transaction properly. Now, because just like the law of negligence, right, we're told, right, in order to hold someone liable, you need to prove causation. So in other words, you need to prove it was that person's action or inaction that caused the loss or suffer. Now here, in this case, based on the facts, what the court held was, despite the fact that Mr. Dunn was liable, on the facts, his action or inaction did not cause the loss suffered by the company. So as a result of that, right, in law, although he was liable, but on the facts, okay, he was not personally liable for the loss suffered by the company. Now, another issue that we look at, right, is something called the conflict of interest and no secret profit. Now, let's suppose you are a director of a company, okay? And at the same time, perhaps you and your wife or your friend or family member has another company operating. Now, let's suppose you want to sell the assets of your company with your wife to the first company. Let's say company A, company B. Okay, let's suppose you're both the shareholders and directors of company A and company B. Supposing you now want to sell the assets of company B to company A. Now the question is, can you do it? And what is the legal consequence? Now let's first discuss in a 1914 case called Transvaal's Land Company versus New Belgium Transvaal Land and Development. Now what happened in this case was Transvaal Land was a company which was involved with New Belgium Transvaal Land. Now there were two directors in Transvaal Land. They were called Samuel and Harvey. And at the same time, there were also shareholders of New Belgium Transvaal. And Samuel was also at the same time a director of New Belgium Transvaal. So basically, both of these parties had stake in both companies, okay? Let's call them company A and company B, okay? So these shareholders and directors, they had stake in both company A and company B. Now what happened was, Samuel and Harvey, they managed to convince Transvaal's other director to agree to have Transvaal purchase some property from New Belgium Transvaal. So in other words, they convinced the directors of company A to purchase assets from company B, which they also had a stake. Now, when that happened, they did not disclose their interest in New Belgium Transvaal to the other directors in Transvaal Land. And the issue before the court was that Samuel and Harvey breached their duties to avoid conflict of interest. And the ruling in the Court of Appeal held, yes, of course, right? Of course, Samuel and Harvey breached their duties. And according to the court, they should have disclosed their interest in New Belgium prior to the purchase. And as a result of that, the purchase transaction was rescinded by Transvaal Land. Now also, if you look at Articles of Association and Regulation 19 of the company, right? Directors of the firm where a director is a partner, remember, can contract with the company provided proper disclosure is made. Now basically what that means is, right, it doesn't mean that as a director or shareholders of another company, you cannot persuade company A to contract with that company. Okay? In law, you can still do that, so long as you make proper disclosure at the first place. So it is possible for company A to buy from company B, or vice versa, so long as the directors and shareholders make proper disclosure at the time when the transaction is proposed. Now today, under our company's ordinance, that is provided under section 536 of the company's ordinance. Okay? So if you are an interested director, if you want to sell assets, for example, in this case, right, company A to company B, right under section 536 to 538, you would have to disclose your interest at the time when the purchase proposal is being made. Now, another issue, okay, is let's suppose you are a director, and let's suppose you are negotiating a business deal on behalf of the company. Now, let's suppose here, the other side secretly tells you that it does not want to deal with the company. And it says, instead, we want to deal with you personally. Now, then the next question is, can you as a director take that business opportunity? Can you as a director take that business opportunity at a personal level? Now this was first discussed in the case called Regal Hastings versus Gulliver. Now what happened in this case was, Regal, they own a cinema in Hastings. And what they decided to do, they took out leases on 2 more cinemas through a new subsidiary called Amalgamated, in order to make the company a more attractive sale package. So in other words, they decided to expand the business and set up a new subsidiary called Amalgamated to make the company look bigger. However, the landlord of the 2 new cinemas wanted them to give a personal guarantee. So wanted the directors to give personal guarantees. But the facts turn out that the directors did not want to give out the personal guarantees. So instead, what the landlord suggested was they could raise up the share capital to £5,000. Okay, so the landlord suggested that perhaps you could raise up the share capital to £5,000, in other words, to make your company more worthwhile. Now, and then they took up the proposal. Now, Regal himself, he put in £2,000, but he could not afford more. And then he asked 4 other directors to put in £500 each. And the chairman, Mr. Gulliver, also put into £500. And the board also asked its solicitor to put in the remaining £500. So that was how they raised the extra £5,000. Okay? The directors, the chairman of the company, and the solicitor of the company. Okay? So they all together came with that extra £5,000 and the company issued the share capital to these directors and the solicitor. Now, to cut a long story short, what happened was they eventually sold the business and made a profit. Now, the new shareholders, the new buyers who bought the company, later discovered this and brought an action against the chairman, the directors, and the solicitor, saying that the profit was in breach of their fiduciary duty to the company. So in other words, what the new shareholders argued was they made this profit simply because of the fact that they were directors of the company and learned of the business opportunities. Now, the House of Lords held that as directors, they were in breach of their duties because they took advantage of an opportunity that the company would otherwise be interested in, but was not able to take advantage. Okay? Make sense? Okay, so they were breach of their director's duty because they took advantage of an opportunity that the company would otherwise be interested in, but was not able to take. In other words, what the court is saying, right, that opportunity, that business opportunity, originally belonged to the company. And they only learn of that opportunity merely because they were directors and solicitors of the company at the time. In other words, when they learn of that opportunity, right, that opportunity should have belonged to the company and not themselves. And by making a profit in the subsequent sale of the business, the profit therefore belongs to the company and not themselves. And what the House of Lords held was the profit, the directors were liable to account for the profit in the interest of the company, so the profit was therefore held on a constructive trust for the interest of the company. Now, but if you look at it from a commercial perspective, right? From a commercial perspective, right? The decision actually does not make much sense. Because the only party who actually lose out in the deal was the new shareholders of the company. Now, because throughout the dealings, okay, there was nothing in the facts that suggested the directors or the solicitors acted in bad faith. Okay? This was all done in a transparent manner. Okay, there was nothing to suggest that they were dishonest. Now, because remember, right, they only took up this business opportunity because at the time, the company could not afford to take it up. Now, the new shareholders of the company were only angry because these directors made a profit by selling the company to the new shareholders. So the only party that actually suffered a loss here was the new shareholders who bought the company at a much higher price. Now, what the court did suggest here, was, right, the company, before it was sold, the shareholders of the company could have rectified the deal, okay? The shareholders of the company could have or should have rectified the deal. Because if the company had rectified the deal, the directors would then not be held liable for this breach. Now, as we'll look at later, okay, this rule nowadays, okay, has been relaxed somewhat. This rule has been relaxed somewhat. especially in parts of the Commonwealth and also here in Hong Kong, something that we'll look at later. Now, the reason why we have this rule is because historically, the law governing directors' duty was borrowed from the concept of trust, was borrowed from the concept of fiduciary duties in the law of trust. And as a trustee and a fiduciary, you owe absolute loyalty to the beneficiaries. And that also meant, as a fiduciary, you should not make secret profit at the expense of your beneficiary. And that's the reason, why we have this rule in Regal Hastings versus Dolan. Now, if you study the law of trust later on, right, you would also come across this case, Regal Hastings versus Dolan. And the principle is exactly the same. The facts and the principle is exactly the same. Now, nowadays, right, as I mentioned earlier, right, if you are an interested director in a deal that involves you and the company, number one, you need to make disclosure. And it is, of course, the general meeting or the board meeting where the disclosure is made. For example, if you look at disclosure under our company's ordinance, right, to be made to the directors, section 536 to 538. In the case where company with sole directors, where the company is required to have at least 2 directors. So in other words, if you are an interested director in any transaction that involves you and the company, it is now a requirement that you make disclosure to the shareholders and to the board. Now, providing that you made that disclosure and follow the proper procedure, there is nothing to stop you as a director, for example, selling your assets to the company. So long as the deal is rectified by the general meetings and the board of directors. So, for example, if you want to sell a piece of land to the company, providing that you disclose that to the shareholders and to the directors, you can do that. Now, what if there was an opportunity, so as directors, there was an opportunity offered to the company, and then you secretly take that opportunity away from the company. Let's supposing you were negotiating a deal on behalf of the company, and the other parties offer to you, why don't you deal with me at a personal level? I don't want to deal with the company, but I want to deal with you at a personal level. Or what if some directors in the company, let's say, they dislike the other director, and then they take the business opportunity away from the company and set up another company? Can they actually do that? Now, this was first illustrated in a Canadian case called Cook versus Deep. Now, what happened here was, the company in question was the Toronto Construction Company, and they had 4 directors, Mr. G.M. Dietz, Mr. G.S. Dietz, and Mr. Hintz, and Mr. Cook. Okay, so 4 directors. Now, the company was involved in the construction of railways in Canada. And a dispute later occurred between the first 3 directors and the other director, Mr. Cook. So what the first 3 directors wanted, they wanted to exclude Mr. Cook from the business. And they eventually took a contract with the Canadian Pacific Railway Company in their own names, excluding Mr. Cook. And at the board meeting and the shareholders' general meeting, they passed a shareholder resolution declaring that the company had no interest in the contract. Now, later on, when Mr. Cook discovered this, he claimed that the contract did belong to the Toronto Construction Company, and the shareholder resolution rectifying that action should not be valid because the 3 directors used their votes to carry it on. Now, the final decision was made by the Judicial Committee of the Privy Council when the most superior court in Canada was still, back then, was still the PC. Now, the Privy Council held that the 3 directors had breached their duty of loyalty to the company. And they also held that the shareholder rectification was a fraud committed on Mr. Cook as a minority shareholder and therefore was invalid. And the court held that the result was that the profits made by the other 3 directors on this business opportunity were to be held on a constructive trust for the Toronto Construction Company. Okay, so the profits made by the other 3 directors held on a trust for the interests of the company and the minority shareholders. Okay, we'll take a short break and come back and continue this, okay?